How does one qualify for Medicaid or medical assistance under the laws of the state of Pennsylvania? First of all, you have to spend your countable assets, meaning basically anything you own, if you're a single person, down to $8,000 if you're high income or $2,400 if you're low income. In addition, you also have to do that in a compliant manner, meaning you can't give everything away today, applying for nursing home care tomorrow, and expect the state to pay your bills. Under the old rule, they were able to look back 3 years at these gifts. Under the new rule, they look back 5 years, and it's even worse than that. How do we adjust to protect assets? Well, it's critical now to protect assets by getting that 5-year clock running. Meaning, if you made a gift today and stayed out of the nursing home for 5 years, they could no longer see that gift, and those assets would be protected to go to pay for long-term care. How we structure that is we use what we call an asset protection trust. And there's some advantages to using an asset protection trust rather than distributing the asset right to a child. We had several clients with a situation very similar to this. They said, "Jim, we have a daughter and we own our daughter's house. And you need to know that we refer to our son-in-law as the outlaw. If we sign the house over to our daughter and she gets divorced, does he have any say-so in the house?" I said, "Absolutely he does. The son-in-law has a spousal interest in the property, so that if they get divorced, he would have an interest in that house." They said they didn't like that idea. They said, "Well, if we keep that house, if we need skilled care, if we have to go to a nursing home, can they kick my daughter out of the house?" And I had to answer them, yes, they could. If you enter into a nursing home, the only home that is exempt is your own home. Now, they can still lien it and take the equity out potentially if things aren't planned correctly, but what this means is that the daughter's house would have to be liquidated and sold and the proceeds used to pay for care. They said, "What can we do?" Well, I said, what we can do is put that house in an asset protection trust. For purposes of Medicaid, that gets the 5-year clock running so that after 5 years, even if both of you need long-term care, they can't kick your daughter out of the house. But legally, that house isn't your daughter's yet either. Meaning if she was to get divorced or get sued, legally she doesn't own the property till you both pass away, so we don't have to worry about the house going to the outlaw, or for that matter, to the creditors or predators of the daughter. By planning ahead of time, we can get that critical 5-year clock running to help protect assets, first and foremost for you, as well as for your beneficiaries. For additional information on other topics regarding estate planning, please call us at 1-800-879-0984, or you can visit us on the web at www.shieldsandboris.com. The Elder Law Offices of Shields and Boris, helping you protect your family legacy.